Hello everyone. Today we will be discussing international law, the definition and characteristics of international law, and there is one question arises in the international law, that is it a proper law or not, and then the types of international law. There are mainly two types of international law. First one is the public international law, and the second one is private international law. So before we study the definition of international law, we have to see a little bit of historical background. International law was initially known as law of nations. It was known as law of nations. The year of 1889, the famous jurist of England named it as international law. Let's now see the definition by Schwarzenberger. The international law is a group of legal rules which apply to sovereign states and other units which have international personality. Now, who can be these other units? They can be international NGOs or any type of organizations or persons who have international presence and work in more than one country. So these international laws are also applied on them. Now let's focus on the characteristics of international law. What is international law? How does it work? What are its sources? And all these things we will understand in the characteristics of international law. Now let's look at the characteristics. The first one is applies on the state, people and other units. States, they use it for mutual relations. It helps to regulate the mutual relations of states and to control the behavior of people on the international level. And other units, these can be NGOs or any other units, they have international presence. It can be international companies or these big social media companies or any other companies or units or private businesses or public businesses that has international presence. Now we will look for the sources of the international law. The sources are, it is based on conventions, the convention, international conventions, international treaties and the customs. These are the sources of the international law. Now there are different theories for it. The first one is naturalistic theory and the positivity theory. The naturalistic theory tells us that all the laws are formed by the god or the nature, and these are considered as divine law. So men are supposed to follow these laws as a divine order. The jurists who follow naturalistic theory, they say that like any other rule, like any other law, the international law is also based on the natural law. So this should be followed, and this is called naturalistic theory. Positivity theory tells us that it is based on the mutual consent of the nations. They voluntarily agree to follow these rules. So this is called the positivity theory, and we have seen the naturalistic theory. Now let's address the question, is international law a law in proper sense? Like some jurist agree to this, some jurist doesn't agree to it. Some jurists say that it is not a proper law because there is no fear of sanctions. So before we understand is international law a law in proper sense, we have to look for the definition of the law. What is the law in the first place? So before we understand is the international law a law in proper sense, we need to understand what is law. What is law? What the jurist says about the law. So Austin has defined law as, behind compliance of law there is fear of sanctions, that is physical force. There cannot be any law, people will not follow a law if there is no fear, no fear of sanctions or fear of force. Like a person would go and do any bad thing if he has no fear of law. In the compliance of the law there should be existence of physical force. There are many arguments about it, so let's see some points in the favor of this argument and against this argument, and then we can decide is this international law in proper sense or not. So now let's look for those arguments. Now the people who say no, the international law is not a law in proper sense, they say no proper sanctions. The first point of them is there is no proper sanctions, and the second is no fear of compliance. Now the jurists who say yes, the international law is a law in true sense, their first argument is it is moral and legal. That the international law is not just moral, it is also legal. All the all the all the nations accept it. They do not deny the existence of it. States don't deny the existence of international law. They might somehow interpret in their own way. They can sometimes violate some rules, but they say no, it was for the good of the people. So they might sometimes violate some rules, but no nation denies the existence of international law. Now the third point is it is based on the treaties and conventions. Treaties, conventions, and one more thing, the customs which are existing from a long time, and these treaties and the conventions that people that the treaties and the international conventions that exist between the all the nations. And now fourth point is existence of UN. The existence of UN is also a proof that yes, international law exists. Treaties are binding to all the parties, the parties that are involved in the treaty and the parties who are not involved in the treaty. So to maintain the order and law on the international level, this article 94 of the UN Charter does help. So in essence, we can say international law is a law in the proper sense. Let's look at the types of the international law. As I already mentioned, there are two types of international law. First is public international law, and the second one is private international law. So now first look at the public international law. Public international law, it is same for all the states. It is common for all the states, all the nations. Second, mainly controls the behavior of the states and to some extent individuals. It also controls the individuals, but the main purpose of the public international law is to control the behavior and their mutual relations of the states or the nations. And the sources of public international law are customs and treaties. The international treaties and the customs, these are the sources of public international law. When we already know what is public international law, so let's now focus on the private international law. It determines the conduct of individuals. What is the main purpose of the private international law? To determine the conduct of the individual, not the states. For the states there is public international law, but the private international law only controls the conduct of the individuals. The second point we see here is it is the part of state law, and it is framed by the state legislative assemblies. The state legislative assemblies frame these laws, not any international organizations or UN, and it is different for different states. It's obvious, like every country follow different rules, they have different constitutions and different laws and rules and regulations. So that's how these private international laws also work. They are different for the different states, they are made by the state legislative assemblies, and they are only applicable to the individuals. Now let's summarize this video in few seconds. The initial name of the international law was the Law of Nations, and then in 1889 the English jurist Jeremy Bentham named it as international law, and from then on we still call it international law. What is international law? International law is the law that controls the behavior and mutual relations of the states. There are two types of international law. First one is public, and the second one is private international law. Public international law is made for the states only, but it can to some extent control the conduct of the individuals, and the private international law is only for the only for the individuals, and it is made by the state assemblies. The public international law is based on the treaties and conventions that are done on the international level, and the customs obviously. And there are two types of theories, the positivity theory and the naturalistic theory. Naturalistic theory says all laws are divine and made by the god, so people should follow those rules. And the naturalistic theory says that it is based on the mutual consent and treaty and organizations. Then we address the one question, is the international law in proper sense? Like, if some people still believes that there are lack of sanctions, lack of fear of force. There are some rules in the UN Charter like Article 94 and other rules that controls the behavior of the nations, that make sure all the states follows the treaties they make on the international levels. That's all for today. Thank you very much. Have a good day.